This time, the police departments and the National Organization for Women and Planned Parenthood realized going after 20,000 people that were involved in clinic protests was not going to be a successful strategy. So let's try to cut it off at the head. How do you do that? You go after the leaders.
In December of 1990, my brother and I and several others volunteered to stand on a sidewalk outside of a post office, behind which was an abortion clinic controlled by a federal judge's order, and distribute New Testaments and tracts. That day, we encountered perhaps a couple, 3 persons who were going in and out of the building in order to go to the clinic. And we were eventually charged with 5 counts of violating the federal order, which prohibited certain activities, which included blockading or harassing. But in this case, there were no blockades. The purpose was first and foremost to reach that woman's soul. And then, of course, attempt to persuade her that her child was equally entitled to the right to life. And that eventuated in what is now the Supreme Court case, Schenck versus pro-choice.
You'd be content if we modified that so only verbal indications would suffice?
No, Justice Scalia, we would not. That would be certainly a step in the right direction. The ACLU in their brief has acknowledged that.
And that's not really what you're after.
That is not. We think that the no consent, and that's what this is, without consent, the speech stops. And that could be before a word is even uttered. And we think that provision of the injunction, like the no approach zone in Mattson, because it is dependent upon consent of the people speaking and the people that are listening. Therefore, it is unconstitutional. The noise provision, Justice Scalia, is excessively loud noise to be heard inside.
To be heard inside, but yes. You wouldn't say that this injunction would be okay if it prevented the counselors from shouting at
No, I think that's robust speech. I mean, this court has talked about the need to protect robust speech in public forums. This is clearly a public forum. The fact that these sidewalks abut an abortion clinic does not mean that they become enclaves immune from the First Amendment.
A major legal victory for anti-abortion activists tonight. The Supreme Court said the right to free speech does include the right to surround women entering an abortion clinic.
By an 8-1 vote written by Chief Justice Rehnquist, the court today struck the bubble zones down, saying speech is at its most protected on public sidewalks. The court said bubble zones go too far, restricting the speech of anyone who wants to stand and chant, shout, or hold signs peacefully.
We were looking for the right to speak our minds and our consciences, and we won that right today.
A lawyer for the New York protesters says today's ruling will bring back some kinds of demonstrating that had stopped.
You'll see prayer vigils, literature distribution, signs, and sidewalk counseling. Those days are going to return. People will not be afraid that they're going to go to jail for handing out a piece of literature.
Rob Schenck always talks about the fact that, and so does Paul, they talk about the fact that they love having the case at the Supreme Court of the United States that says Schenck versus pro-choice network. Because it was good that they were versus against the pro-choice network, and of course ultimately we won that case at the Supreme Court overwhelmingly.